Vande Mataram. Dear friends, welcome to my channel, Courtroom Battles. My name is Dr. TUSHAR MANDLEKAR and I keep on talking on the topics of law and various judgments passed by the Honorable Supreme Court and High Courts in India. If you are a lawyer or interested in law or an aspiring lawyer, please join my channel, Courtroom Battles. Dear friends, today we are going to discuss the power of Supreme Court or High Court to debar an advocate from practicing in courts. The High Courts and the Supreme Court derive this power to debar an advocate from Section 34 of the Advocates Act and Article 145 of the Constitution of India respectively. Article 145 of the Constitution of India empowers the Honorable Supreme Court of India to make rules on the regulations to practice before it. The power to debar must be located within the specific rules and cannot be assumed by the Supreme Court in violation of the principles of natural justice. On August 31st, the Supreme Court of India fined senior advocate Prashant Bhushan ₹1 holding him guilty in his criminal contempt proceedings. If he defaults on the payment, he will undergo imprisonment for 3 months and be debarred from practicing before the apex court for 3 years. Many jurists have opined that the default punishment is unlawful as it is excessive imprisonment for failing to pay the fine of ₹1. Now, the Honorable Supreme Court has held that Mr. Prashant Bhushan would be debarred from practicing in any court for 3 years in the event if he fails to make the payment of ₹1. Although he has made the payment of ₹1 before 15th of September 2020, he has challenged the order of the Honorable Supreme Court. The other interesting angle is whether the Supreme Court has the power to debar an advocate from practicing before the courts in cases where the advocate was found guilty of the contempt of court. This is an interesting question and one that the constitutional courts have dealt with extensively. It is argued here that though the Supreme Court can debar an advocate by way of regulating who can appear before it, the court exercises said power from an unwritten source and this is illegal and wrong. Many jurists believe that rules ought to have been made by the Honorable Supreme Court of India under Article 145 of the Constitution of India. But in absence of such rules, such a power cannot be exercised by the Honorable Supreme Court of India so as to deprive the livelihood to an advocate practicing in the court. It should be kept in mind that in contempt trial, no inquiry is made regarding whether the accused advocate is fit to be a lawyer or not. The inquiry in a contempt trial is regarding how the action of the accused has lowered the position and the dignity of the court, which has led to the obstruction of the justice. Power to debar an advocate is an important power. The question of whether an advocate convicted of contempt of court can be debarred by the courts from practicing the law as dealt with in the case of SCBA versus Union of India. In this case, Constitution Bench of the court upheld the right of Bar Council to try the advocate for alleged professional misconduct. It held that the courts cannot suspend or revoke the licenses of advocates on their contempt and that the said power rests with the Bar Council of India. In a given case, it may be possible for this court or the High Court to prevent the contemner advocate to appear before it till he purges himself of the contempt, but that is much different from the suspending or revoking his license or debarring him practice as an advocate, the Honorable Supreme Court observed. According to the Honorable Supreme Court, as observed in the case of Praveen Shah and Harish Uppal, the functions of an advocate are not restricted to appear and plead before the court, but it also includes other works like legal advisory, drafting the documents, arbitration, and so on. The court also held that when an advocate is guilty of the contempt of court, then in order to preserve the dignity of the court, his right to appear and plead before the court is curtailed. it clarified that it has nothing to do with the revocation or suspension of the license of an advocate, which is within the domain of the Bar Council of India. By debarring an advocate, the court only prevents him from appearing and pleading before the court, while he is free to do all other activities or indulge in other lawful functions as may be permissible in the eyes of the law. The Supreme Court opined that the power to debar an advocate from appearing before the court is rooted in Section 34 of the Advocates Act 1961 and Article 145 of the Constitution of India. The said provision empowers the Honorable Supreme Court or the Constitutional Court to lay down the rules relating to the practice of the advocates before it. The courts, with their power to regulate who can appear before them, are debarring the advocates convicted of the contempt from appearing before them. Dear friends, there is a catch in this situation. The Honorable Supreme Court did not prescribe any rules to this effect under Article 145 of the Constitution of India. Without a written provision for debarring the convicted advocate, the court is exercising the power to debar an advocate from an unwritten source, which is illegal and wrong, observes many jurists. It is true that few high courts like Bombay High Court, Punjab and Haryana High Court and Kerala High Court have framed rules under Section 34 of the Advocates Act 1961. And it said that no advocate who has been found guilty of contempt of court shall be permitted to appear, act or plead in the courts unless he has purged himself of the contempt. By virtue of this rule, an advocate who was held guilty of the contempt can be debarred from appearing before the courts until he purges the contempt of court. But it is interesting to note that a similar provision is missing in Supreme Court Rules 2013, which are framed under Article 145 of the Constitution of India as rules as to the persons practicing before the court. Hence, the power to debar an advocate by the Honorable Supreme Court is a big question today in India. Dear friends, quantum of punishment for contempt and quantum of debarment is also a big question. It is surprising that there is no provision regarding the quantum of debarment as well. In another contempt case decided by the Honorable Supreme Court, Advocate Matthew Natumbara was debarred only for 1 year, whereas Prashant Bhushan was debarred for 3 years. What is the criteria for 3 years? There is literally no provision that holds the court from debarring an advocate for life or for a particular number of years. Unlike some other high courts, which rules say that the purging of contempt may allow a convicted advocate to appear before the courts, the Supreme Court rules have nothing to that effect. It is not enough to have the power to debar an advocate convicted of contempt. It should be clearly provided in the rules along with the quantum of the punishment. An immediate amendment to Supreme Court Rules 2013 may be undertaken to this effect to remedy this anomaly. There is literally no provision that holds the court from debarring any advocate for life, unlike some High Court's rules which say that the purging of the contempt may allow a convicted advocate to appear before the courts. The Supreme Court rules have nothing to that effect. In fact, there was a discussion to that effect in the case of Advocate R.K. Anand regarding what to do in cases where there are no rules to debar the advocate convicted of the contempt. The Honorable Court held that in such cases, courts can overcome the requirement of having the provision by mentioning possible debarment in the initial notice or in the notice issued before sentencing. This is bad law, as by merely serving the notice, the court cannot punish for unknown rule at the time of the commission of the offence or which violates the principle of natural justice. A punishment cannot be imposed from the vague inherent power without having there being rules or the provisions of the rules for a quantum of punishment to that effect. The debarment is a punishment that should flow from a written source which acts as a constructive notice to people not to commit such an act again and again. Such a punishment no doubt acts as a deterrent for other advocates. But the rule of law must preserve, and there has to be some rule by which such a punishment can be given to an advocate. Dear friends, the differentiation created by the law between the right of appearance before the court, which is regulated by the court, and the right to practice before the court, which is created by the bar councils, can appear artificially in few of the cases. Seeing from the lens of the effect test, which is applied in the cases of fundamental rights, the effect of prevention or preventing the convicted person from coming into the courts and practicing in the courts is naturally guided principle from the fundamental right to make the livelihood. The debarment effect, the reputation, revenue and the scope of practice of an advocate, though his right to practice of his license is untouched. To debar an advocate from practicing in courts is nothing but giving a stigma on his license or his reputation also. Although he can be allowed to practice otherwise than coming into the courts and his livelihood can continue, but this has also to be regulated by the courts in particular rules. If the act of an advocate is unworthy of a lawyer, then it should be left to the disciplinary committee of the bar councils that are consistently following the principles of natural justice, and those bar councils are constituted by the peers of the advocates to decide upon the guilt of the professional misconduct as per the bar council rules. For an advocate whose practice is dominated in the field of litigation, which is predominantly the case of lawyers at the trial court level, restricting him or her for appearing before the courts is as good as debarring him from the courts. It can force the advocate to take up other legal activities which they might not have undertaken in their career, like arbitration or drafting or any other agreements. It should be kept in mind that in contempt trial, no inquiry is made regarding whether the accused advocate is fit to be a lawyer or not. The inquiry in a contempt trial is regarding how the action of the accused advocate lowered the dignity and majesty of the court and led to the obstruction of the justice. By making the conviction for contempt of court on a ground of obstructing the justice and debarring him or preventing him appearing in the courts is a great injustice to an advocate. So it is necessary for everybody to think upon this. May the good sense will prevail and the Honorable Supreme Court will make the rules with this regard. Dear friends, if you have liked my video, please like it, please share it, and please be a member of this channel. Please subscribe to my channel. Thank you so much. Jai Hind, Jai Bharat.